Okay, Chapter 13, Part 5. Now we're dealing with the issue of damages. Okay, in contract law, damages compensate the non-breaching party for the loss of the bargain. In order to do this, you have to litigate. You have to go to court. That can be expensive and time-consuming. And oftentimes, they're difficult to enforce. So I cannot emphasize to you as potential business people the importance of this statement. Oftentimes, and I tell this to clients all the time, that the easy part is winning the case and getting a judgment for the amount you're owed. The hard part is collecting that judgment, and we've talked about that, I believe, before. For this reason, most people settle their lawsuits prior to trial. So what are the types of damages? We talked about types of damages in torts. Contracts, fairly the same, but a little bit of difference. Okay, compensatory damages covers your direct losses or costs. Consequential damages covers indirect but foreseeable losses. Punitive damages punishes and deters wrongdoing. And nominal damages exist where there are no actual damages, but you have actually been wronged, and therefore the court awards you nominal damages, which can be $10, $50, $100, something of that nature. Okay, compensatory damages compensate the non-breaching party for the loss of the bargain and replace what was lost because of the wrong or damage. The standard measure for compensatory damages is the difference in the value of what was promised in terms of performance and the value of the actual performance. Okay. Incidental damages are expenses that are caused directly by the breach of contract. So where you have a sale of goods, the damages is the difference between the contract and the market price. For the sale of land, you can get either specific performance as a remedy for the breach. Okay, consequential, or in contract cases, special damages, or foreseeable damages that result from the breach. That's a situation where the breaching party knew or had reason to know that special circumstances would cause the non-breaching party to suffer additional losses. So if you pay somebody, if you're a merchant and you have a store, and you pay somebody to remodel the inside of your store, and they're supposed to complete the contract by a certain date, and for no legitimate reason it takes them 2 weeks longer, your consequential damages may be your loss of revenue for that 2-week period where you would have been reopened for business. Okay. Punitive damages, of course, punish the person for the conduct. Generally, you cannot obtain punitive damages in a contract situation. Those can only be obtained in certain situations where other factors exist, such as fraud. Okay. In nominal damages, of course, we said there's no financial loss, so it's a minimal amount. Now, mitigation of damages is an important concept for people to understand, and most people are not aware of this. The law applies an obligation on a person who has suffered from a breach of contract by the other party to take reasonable actions to limit the amount of damage that they suffer. Okay, so it's the duty of an innocent injured party to reduce the damages that he or she has suffered. And it depends upon the nature of the contract. Okay, so you have to do things to limit those damages. Typically in a contract situation, for example, in a lease, a landlord-tenant contract, the tenant moves out prior to the end of the lease. The landlord cannot simply sit around and do nothing and then sue the tenant for those months that remained on the lease. In that situation, the landlord has to try and rent the unit to somebody else. And if successful, the measure of damages is only the actual loss, not the full amount of time that would have been left on the lease. Okay. We already talked about liquidated damages versus penalties. Generally speaking, if a contract has a provision in it that's interpreted by a court to be a penalty and not a liquidated damage, then the court's not going to enforce it. So liquidated damages are a specific amount agreed to be paid as damages in the event of a future breach. Okay, so for example, if you have a situation in an employment contract where the employment contract says that if you leave before the term of your contract, you have to pay the employer a certain amount. If that amount that was in the contract is not reflective of the actual damages that are being suffered by the employer, then the court may interpret it instead as a penalty, and it would not be enforceable. So looking at it, whether it's liquidated damages, the court's going to look at when the contract was formed, was it apparent that damages would be difficult to estimate in the event of a breach? Was the amount set as liquidated damages a reasonable estimate and not excessive? If not, then it's going to be a penalty. What happens with regard to situations where damages are not sufficient? Damages do not put the person back in the place they would have been but for the breach of contract. There we may be looking for an equitable remedy such as restitution, specific performance, and reformation. Okay? Rescission is where the contract is rescinded. That is, it's set aside, no longer effective. The cancellation of the contract in order to return the parties to the pre-contract position. The failure of one party to perform may entitle the other party to rescind the contract. Remember that rescission is an equitable remedy. In equity, you have to ask the court to apply an equitable remedy. The person seeking the remedy has to come in with clean hands, which means that they didn't do anything themselves that would be considered wrongful, lest the court would lose its equitable powers. Okay, restitution allows for rescission of the contract, and both parties have to restore the other party, make restitution to the other party by returning goods, property, or funds. Restitution can also be available in other situations not involving rescission. Specific performance is where the court actually orders a party to perform what they were obligated to do under the contract. Okay? It avoids some of the problems that might be inherent in a suit for damages. It's usually used in situations involving land and contracts for personal services. It requires that there be something unique about the contract wherein damages are inadequate to make the parties whole. Okay. Reformation is simply where the court uses its equitable powers to provide a remedy by rewriting the contract to meet the true intentions of the parties. Usually fraud or mutual mistake is present before the court will reform the contract. Or there's a situation where for some reason the contract itself did not actually represent the parties' oral agreement. Waiver is a situation where the parties knowingly relinquish a legal right in order to require satisfactory and full performance. In other words, you waive the breach of the other party in a certain situation. When waiver occurs, the party waiving the breach cannot take later legal action. It extends only to that matter that was waived and not to the whole contract. This happens sometimes when the party simply wants to ensure that the remainder of the contract is fulfilled and the benefits from the remainder